August 3rd, 1966. A friend walked into a small house on Hollywood Boulevard and found Lenny Bruce dead on the bathroom floor. He was 40 years old with needles still in his arm. In the next room, court transcripts and legal briefs lay scattered across the floor, the half-finished pages of an appeal he'd been working on alone because he could no longer afford lawyers. The press would call it an overdose, and it was, but that framing would do a lot of work for a lot of people who preferred he stayed quiet. Those people included Manhattan District Attorney Frank Hogan, who had personally driven the prosecution that left Lenny Bruce broke and legally banned from working in New York. The two NYPD detectives Hogan had sent into a Greenwich Village folk club with a tape recorder and a notepad. The New York State Liquor Authority, which had quietly let venue owners know what would happen to their licenses if they booked him. And the club owners across the country who had stopped returning his calls because they'd been watching what was happening in New York. Lenny Bruce died of an overdose on morphine. He also died of 4 years of legal attrition that bankrupted him, isolated him, and ate him alive. The version of the story that leads with a needle is the version that lets a specific group of people walk away from it. I'm Lorne Bregitzer, a professor at the University of Colorado Denver's College of Arts and Media, and on Everything is Gray, we try to make sense of something that's rarely simple, how the artists we admire and the things they've done shape the way we see their work and ourselves. This is the story of how the state of New York killed a comedian without ever having to lay a hand on him. The Rise. In 1958, the most popular comedian in America was Bob Hope. He'd been doing a version of the same act for 20 years. He came out and told topical jokes written by a team of writers and vetted by a network. Then he did a soft shoe routine and sang a song with a guest before going home. His material was professional and the delivery was perfect. There was nothing in any of it that would have surprised a single person in the room. That was the point. Bob Hope wasn't in the business of surprising people. He was in the business of making sure that nobody in the audience felt nervous. Most American comedy in 1958 worked that way. Milton Berle, Jack Benny, Red Skelton, and the Borscht Belt comedians who came down off the mountain to work the Catskill circuit and the New York clubs. The material was vetted, the structure was tight, and the act was the same on Tuesday as it was on Saturday. You knew exactly what you were going to get. Lenny Bruce was doing something else. To understand what was eventually done to him, you have to understand what he was actually doing on stage, and you have to understand how new it was. What he was doing, and this is the part that gets lost in the mythology around him, was importing the structure of a jazz solo into stand-up comedy. He had grown up around jazz musicians. He had worked with them and he thought like them. A Bruce set wasn't a series of polished bits delivered in sequence. It was a riff that started somewhere, drifted somewhere else, and then ended up in a place that neither he nor the audience had expected when the set began. He would seize on words like obscene, Catholic, Jewish, or communist, and follow it down a rabbit hole, doing voices, switching dialects, breaking off mid-sentence to ask the audience whether what he had said was true. The set wasn't the same on Tuesday as it was on Sunday. Sometimes the set wasn't the same on the second show as it was the first. The closest thing American comedy had to a comparison point was Mort Saul, who'd been working at the Hungry Eye, a small basement club in San Francisco's North Beach, since 1953. Saul came on stage with a folded newspaper under his arm and did political commentary in a sweater. He was sharp and he was fast. He had broken open a space for comedy that engaged with what was actually happening in the country. But Saul's material, for all its bite, was still essentially editorial. It was a column read out loud by a man who happened to be funny. Bruce was doing something Saul wasn't. Bruce was using the stage as a courtroom in which he was simultaneously the defendant, the prosecutor, and the judge. He would take a piece of language, whether it was a slur, a euphemism, or a phrase from a sermon. He would put it on trial. He would play the role of the racist, the priest, the politician, the cop, the hipster, and the square in the same 5 minutes. And he would let the audience decide which one was telling the truth. And sometimes none of them were. And sometimes all of them were. The point was that the question had been asked. The clubs who gave him a home for this were specific. They weren't the rooms Bob Hope was working. The Hungry Eye in San Francisco, run by a man named Enrico Manducci, who had built the club to the most important room in West Coast comedy. The Crescendo on Sunset Strip in Los Angeles, where Bruce was a regular by 1958. Ann's 440 in North Beach, a club with a largely black clientele where Bruce had been working since 1957. The Den in Beverly Hills, the Jazz Workshop in San Francisco, which would matter later for reasons nobody could have predicted. These were small rooms, mostly 200 seats and under, with liquor license, and that detail will matter more than it sounds like it should. The live comedy albums came out of these rooms. Fantasy Records, a small jazz label out of San Francisco, released Bruce's first major album in 1958. It was called Interviews of Our Times, and it presented Bruce in his characteristic structure doing long-form riffs that played multiple characters, the comedian as a ventriloquist for the country's anxieties about itself. The album sold to college students, jazz musicians, beat poets, and the kind of urban listener who was looking for something the radio wasn't playing. The follow-up came in 1959. It was called The Sick Humor of Lenny Bruce, a title that took its cue from a Time magazine article published earlier that year. The article had grouped Bruce with Mort Saul and a handful of others under the heading The Sicknicks. Time meant the label as a diagnosis. Bruce, characteristically, took it as a compliment. That album was nominated for a Grammy. Television wasn't an option, and that's worth being precise about. Steve Allen had Bruce on in 1959, once, under a set of content restrictions so strict that what aired bore almost no resemblance to what Bruce did in the clubs. Ed Sullivan wouldn't have him. Jack Parr wouldn't have him either. The Tonight Show under Parr, and later under Carson, would feature Bob Hope dozens of times, Mort Saul periodically, and Lenny Bruce never. The networks had decided early that Bruce wasn't someone they could put in front of an advertiser. The major radio stations had reached the same conclusion about his records. Whatever Bruce was doing, the only place he could do it was in a club, in front of a paying audience, late at night. There were maybe a dozen such rooms in the country, each one a deliberate exception to what the rest of the industry was willing to book. The trouble in 1958 was mostly imagined. The clubs got the occasional complaint, and the records got the occasional negative review. The parents of college students who came home with the LPs were occasionally horrified, but none of this had any teeth. The First Amendment had been used to protect the publication of Allen Ginsberg's Howl in San Francisco in 1957, 2 years before, in the case that established a firm legal standard for the kind of work Bruce was doing. On paper, the legal ground Bruce was standing on was solid as it could be. The Howl ruling was recent. The Ross standard from the Supreme Court was clear. Any reasonable reading of the case law said that satirical and political work using rough language was protected speech. What Bruce didn't know in 1958 was how thin that paper was. He didn't know that police vice squads in San Francisco and Los Angeles had started attending his shows. He didn't know that the legal protection he assumed he had, the First Amendment, the Howl precedent, the simple fact that what he was doing was clearly art, would turn out to mean very little. None of it would survive a sufficiently determined prosecutor deciding to find a way around it. The prosecutor was already at his desk in Lower Manhattan. What he was actually saying. What Bruce was saying on stage, when he got to the material that the prosecutors would later seize on, was actually an argument about language. Hold on to that distinction, because it's the distinction that the prosecutors would systematically refuse to acknowledge. He wasn't telling dirty jokes. He was making a case about why certain words made people uncomfortable, and what discomfort was actually about. Take the bit that became known as Religions Incorporated. It opens with a phone call. Oral Roberts is on the line with a pope, who Bruce calls Johnny. They're talking like two executives reviewing the quarter. Roberts wants to know if they should run a sale on rosaries. He asks whether the pope can do a personal appearance in the Midwest because the numbers in Cleveland are soft. Roberts mentions a problem with one of the other product lines. The pope, in Bruce's voice, sounds tired and a little annoyed at being interrupted. The bit goes on for several minutes. By the end, you've heard a complete portrait of organized religion as a commercial enterprise, with the merchandise, the territorial rivalries, the celebrity endorsements, the soft markets. Nobody in the bit says anything obscene by any conventional measure. There are no slurs, there's no profanity. The bit is structured entirely as a phone conversation between two businessmen. The reason it caused trouble wasn't the words, it was the argument. Bruce was saying that American religion in 1959 looked a lot like American business in 1959, and the resemblance was something that people running both made a living by pretending not to see. That was what was offensive. The bit was prosecutable in a way that it actually got prosecuted, by people pulling individual phrases out of context and reading them to a jury. What made it culturally dangerous was the case it was making. Lenny Bruce's Lone Ranger bit worked the same way. Bruce imagined what would happen if the Lone Ranger stuck around long enough to receive the thanks of the people he saved. The townspeople gathered. They want to thank him. He doesn't know how to be thanked because the whole structure of the character is that he leaves before anyone can. The town people insist. They ask him what he wants, and after enough pressure, he asks for something. And what he asks for is a kiss from one of the women in the crowd, and the room goes silent. The bit is about what we want from our heroes, what happens when our heroes turn out to want something back. Again, the words themselves aren't the point. The question is what makes the bit uncomfortable. The words are just a carrier. And then there was the bit about the racial language, which is the one Bruce is most often remembered for and most often misunderstood about. The setup is that Bruce is on stage scanning the audience and identifying, in the most offensive word available, every ethnic group he can spot: Italians, Jews, Irish, Chinese, black audience members. He goes through the list and the room gets tense. Then he makes the argument the bit was actually for. He says, suppose the President of the United States went on television tonight and used the most offensive word for black Americans over and over in every speech for a year. By the end of the year, Bruce argued, the word would have no power left. The reason the word had power, Bruce said, was that it was being suppressed. The wound it produced was a function of the silence around it, not the word itself. Bring the word into the open and use it constantly, and that wound would dissipate. The bit was an argument made on stage in real time about how language acquired the capacity to hurt and how that capacity could be diffused. You can disagree with Bruce's argument, and many people did, both then and now. There are serious objections to the position he was taking, but the argument was the whole point of the bit. The argument was the thing the bit existed to make. And when prosecutors got a hold of the material, they didn't engage with the argument. They couldn't, because the argument was a defense of what Bruce was doing, and engaging with it would have collapsed the case. So they did the only thing they could do. They took the words out of the bit, lined them up on a piece of paper, and handed them to a jury. That was the prosecution's entire method in every city: strip the argument out, present the language in isolation, put the jury in a room under fluorescent lights, strip the audience, the rhythm, the setup, let them react to the words the way anybody would react to them in that environment. The conviction was built into the staging. It was a closed loop. Bruce would make an argument on stage that certain words had power because they were forbidden. The prosecutors would prove the argument by forbidding the words. The argument and the prosecution were the same thing in two different rooms. Who actually came for him? The campaign against Lenny Bruce wasn't a campaign in the sense that anyone sat down and planned it. It was a series of decisions made by individual prosecutors, vice cops, and licensing officers in 3 different cities over 4 years. Each one made sense to the person making it at the time, and which together constituted the most sustained legal effort against a single performer in American history. The first arrest happened on October 4th, 1961, at the Jazz Workshop in San Francisco. Bruce had been working the workshop for several weeks. The set that night included a bit about the San Francisco Chronicle in which he used a single word that the SFPD Vice Squad had been waiting to hear. 2 officers, present in plain clothes, signaled to one another and went backstage. They arrested Bruce in his dressing room between sets. The charge was violation of California Penal Code Section 311.6, using obscene language in a public place. The word in question was a single compound noun referring to a sex act used once, in the context of a longer riff in which Bruce was actually making fun of the San Francisco Chronicle's coverage of a city council meeting. The arresting officers weren't freelancing. The SFPD Vice Squad had been attending Bruce's sets for some time. Multiple officers were assigned to monitor his shows, take notes on what he said, and identify any language that could form the basis of a charge under the state's obscenity statute. The October 4th arrest was the result of that surveillance reaching its threshold. 2 things mattered about the San Francisco arrest. The first was that Bruce was acquitted in March 1962, after a jury heard the bit in context and concluded that what he said was protected speech. The second was that the acquittal only protected him in California. The decision had no force in any other state, which the prosecutors in other cities that came next understood. And Los Angeles was the city that happened to come next. The LAPD Vice Squad arrested Bruce at the Troubadour in West Hollywood on October 1962, on essentially the same charge. They had sent essentially the same surveillance into essentially the same kind of room. The LA County DA's office prosecuted. The first trial ended in a hung jury. The second one ended in acquittal. The pattern was now visible to anyone paying attention. Police vice squads in major cities were sending plainclothes officers to Bruce's shows. The officers were taking notes, and then those notes were going to the DA's office. The DA's office were filing charges. Those charges weren't winning convictions, but they were costing Bruce defense bills that ran into the tens of thousands of dollars for each case, and they were generating press coverage that made other clubs reluctant to book him. Then in early 1964, the case came to New York, and the formula had changed. The Manhattan District Attorney in 1964 was a man named Frank Hogan. He had held the office since 1942, which made him the longest-serving DA in the history of the borough. He was known throughout the city as Mr. District Attorney. He was a devout Catholic. He had a close working relationship with the Archdiocese of New York under Cardinal Francis Spellman. Hogan's office reflected Spellman's moral and political priorities with some consistency. He had never lost an election, and by 1964, he had been re-elected so many times that opposing him was understood inside the Democratic Party as a career-ending move. Hogan ran his office as a personal fiefdom, and the cases his lawyers took on were the cases he wanted them to take on. His office had a long-standing interest in obscenity prosecution. Hogan's lawyers had successfully prosecuted the publishers of Henry Miller's Tropic of Cancer in 1962. They took on bookstores that stocked material the archdiocese objected to. They had built working relationships with the city's licensing authorities. Together, they could move against venues that hosted material the office considered prosecutable. By the time Bruce booked an extended run at the Cafe A Go-Go on Bleecker Street in 1964, Hogan's office had been waiting for exactly this kind of opportunity for some time. Bruce wasn't the first comedian the office had considered prosecuting. However, he was the first one whose material, in Hogan's lawyer's assessment, would actually convict. This was a first of a different kind. Hogan had been prosecuting obscenity for 2 decades, but his office had never before brought charges against a comedian for a live performance. The reason was not that Bruce was the first comedian to use the language he used. He wasn't. Belle Barth had been working blue in clubs for years. Rusty Warren's records were vastly more explicit than anything Bruce ever recorded. They sold under the counter at record stores across the country. Red Fox put out so-called party records on the Dew-Tone label, sold mostly to black audiences. The material on them would have made Bruce's prosecutors leave the room. None of those performers was ever prosecuted by Hogan's office, or by any other major district attorney. The difference was the content. Belle Barth and Rusty Warren told dirty jokes. Bruce made arguments about religion, race, and the American government. That's what Hogan's office wanted off the stages of New York. Obscenity was a statute that gave them a way to do it. The man Hogan's office sent to the Cafe A Go-Go to gather evidence was named Herbert S. Rue. Rue wasn't a police officer. He was an inspector for the New York City Department of Licenses, the agency that issued and revoked the cabaret licenses every nightclub in the city needed in order to operate. He was also a former CIA officer. He was middle-aged, conservatively dressed, and entirely out of place in a Greenwich Village folk club. Herbert Rue attended Bruce's performance on multiple nights in March and April of 1964. He sat in the audience. He took notes on a small pad. He wrote down the words Bruce used and the order he used them in. He did not, by his own later admission in court, take notes on the structure of the bits, the audience reactions, or the arguments Bruce was making between the words. He only took notes on the words. The notes became the basis for the indictment. Hogan's office filed charges against Bruce on April 3, 1964, after Bruce's first run of shows. The charges were filed not just against Bruce, but against Howard Solomon, the owner of the Cafe A Go-Go, on the theory that allowing the obscene performance to take place on his premises was itself a prosecutable offense. The point of charging Solomon was structural. By making the venue owner a co-defendant, Hogan's office was telling every other venue owner in New York what would happen to them if they booked Bruce. The message was understood immediately. Bookings for Lenny Bruce began to disappear that week. Behind Hogan's office stood another office that didn't have to file charges to do damage. That office was the New York State Liquor Authority, or the SLA. The SLA held the licenses that every club in the city needed in order to serve alcohol. Under New York law at the time, the SLA could revoke a license without a criminal conviction. The agency only had to find internally that a licensed premises had hosted material it considered indecent. The SLA didn't have to prove anything in court, and the license could be pulled then in a matter of days. The SLA never formally moved against Cafe A Go-Go because it didn't have to. The threat alone was sufficient. Howard Solomon understood, and every other club owner in the city understood, that booking Lenny Bruce after the indictment would put their license at risk. The Cafe A Go-Go itself, despite Solomon's loyalty to Bruce, would lose its cabaret license the following year on a separate matter that the city pursued with obvious energy. Whether the two events were related isn't something anyone in the licensing office or the DA's office ever said on the record. The message landed without anyone having to deliver it. The club owners across the country were watching. They'd been watching since the San Francisco arrest in 1961. They had watched the LA prosecutions in 1962 and 1963. After New York, the calculation became simple. Booking Bruce didn't just expose a club to the possibility of being raided by a vice squad. It exposed the club to the certainty that the local equivalent of the SLA, which every state had, would receive a phone call from somebody, and the club's license would come under some kind of scrutiny it couldn't afford. Bruce's fee had dropped, but his booking still collapsed. By the middle of 1965, in most American cities, there was no club owner willing to put him on stage. This was the structure of the campaign against Lenny Bruce. It wasn't a single conspiracy, it was Frank Hogan in Lower Manhattan. It was Herbert Rue with his notepad in Greenwich Village. It was the SLA's licensing officers in their offices uptown, the LAPD Vice Squad on the Sunset Strip, and the SFPD Vice Squad in North Beach. And it was the club owners in city after city making the only commercial decision available to them. Each of these people were operating within their own jurisdiction and their own job description, and together they killed his career. The trials. There were 3 trials in 3 cities between 1961 and 1964. The first happened in San Francisco, the second in Los Angeles, and the third one in New York. Each trial had a different bench and each ended differently. Together, they told Bruce the story of what was happening to him. The first was in San Francisco in March 1962, 4 months after the Jazz Workshop arrest. The case was tried in front of a man named Judge Clayton Horn. That mattered. Horn was the judge who had presided over the Howell trial in 1957 and acquitted Lawrence Ferlinghetti and City Lights Books on charges of distributing obscene material. Horn knew what was at stake when free speech cases came in front of him, and he knew the Supreme Court's standard for obscenity that had been laid out in Roth v. United States in 1957. The standard was that material was obscene only if its dominant theme, taken as a whole, appealed to a prurient interest under contemporary community standards. The phrase, taken as a whole, was the load-bearing one. It meant that words couldn't be lifted out of context and prosecuted in isolation. The whole work had to be considered. Bruce was defended by a lawyer named Albert Bendick, who had also defended Ferlinghetti in the Howell case. Bendick understood exactly the argument that needed to be made. He brought in witnesses who could speak to what Bruce was actually doing on stage. Ralph Gleason, the jazz critic at the San Francisco Chronicle, testified to the artistic merit of Bruce's work. Lou Gottlieb, a musician who had played the same circuit, testified to the structure of Bruce's performances and the way the language fit into the larger work. Lawrence Ferlinghetti himself testified. He drew the line directly from Howell to what Bruce was doing in the nightclubs. It was the same project, using language that society had marked off-limits in order to examine what the off-limits were actually about. The jury acquitted Bruce on March 8, 1962, after about 4 hours of deliberation. The trial had only taken 3 days. The verdict was unanimous and quick. The local press treated it as a small story. The Chronicle ran it as a paragraph. The San Francisco arrest had not been a major item nationally to begin with, and the acquittal was not a major item now. What the verdict actually represented was a clear application of the Roth standard by a judge and jury who understood the law. Bruce had used a word, but the word was part of a longer riff. The riff had artistic merit, and the entire bit taken as a whole was not obscene. End of case. Except that the verdict was binding only in California, and the prosecutors in the cities that came next knew it. An acquittal under one state's obscenity statute didn't control any other state's prosecution. Bruce could be acquitted in San Francisco 1 month and arrested for the same material in Chicago the next. The legal protection Bruce had won did not travel. Los Angeles came next. The LAPD Vice Squad arrested Bruce at the Troubadour in October 1962 during a benefit performance on charges essentially identical to the San Francisco ones. The LA County DA's office took the case to trial in early 1963. The trial was protracted, contested, and procedurally messy. The first jury hung. Then the second proceeding ended in acquittal. The LA cases were important. They didn't produce any new legal precedent. They were important because of the pattern they established. The LAPD Vice Squad kept arresting Bruce. The DA's office kept filing charges, and the juries kept refusing to convict. And every cycle of that pattern cost Bruce somewhere in the tens of thousands of dollars in legal fees, as well as several weeks of his time. Increasingly, the point of the prosecutions wasn't to win them. The point was to make Lenny Bruce spend the money and the time defending himself. By the time the case came to New York in early 1964, Bruce had been through this loop in California for 2.5 years. He had been acquitted twice. Bruce believed, going to the New York case, that he could win again. But he was wrong, and the reason he was wrong had to do with how New York prosecution was designed. The trial began on June 16, 1964, in the criminal court of the city of New York. The defendants were Lenny Bruce and Howard Solomon, the owner of the Cafe A Go-Go. The prosecutor was an assistant district attorney from Frank Hogan's office named Richard Cuh. There was no jury. Under New York law at the time, obscenity cases of this type could be heard by a 3-judge panel, and Hogan's office had requested that this be heard by them. 3 judges sat on the panel: John Murtaugh, who was the presiding judge and chief of the criminal court, J. Randall Creel, and Kenneth Phipps. None of them were particularly known for free speech jurisprudence. All of them were appointees within the orbit of Hogan and the New York Democratic establishment. The prosecution's strategy was the central piece of the case. Hogan's lawyers had been refining it since the Tropic of Cancer's prosecution 2 years before. The strategy was to keep the actual performance out of the courtroom. Lenny Bruce's defense team, led by Ephraim London and Martin Garbus assisting, wanted the court to hear the performances. They wanted to play the recordings Bruce had made of his sets. They wanted the judges to hear the rhythm, the audience laughter, and the way the bits built. They wanted to put audience members on the stand to describe what they heard and what they had understood. Ka objected to all of it. The judges sustained the objections. The court would not hear the performances. What the court would hear was Herbert Rue. Rue took the stand and read his notes. He was asked to recreate from those notes what Bruce had said on the nights he had been in the audience. He did so in a flat, monotone voice, looking down at his notepad, reading material out loud, one line at a time with no inflection and no setup. He had not noted the audience reactions. He hadn't noted the structure of the bits. He had noted the words, and he read the words. A middle-aged former intelligence officer stood in a courtroom under fluorescent lights. He read aloud the words of a comedian in a voice with no rhythm or comedic timing. There was no audience, no laughter, no setup or callback. The three judges, who would decide whether the work was obscene, were listening to the words alone, in the voice of someone who didn't write them and didn't know how to deliver them. Bruce sat at the defense table watching a stranger perform a parody of his act. The parody was the evidence. The defense argued the point in real time. What Rue was producing in the courtroom was so unlike Bruce's actual performance that it couldn't constitute evidence of what Bruce had actually done on stage. The argument was directly responsive to the Roth standard, the requirement that the material be considered as a whole. If the court was only hearing fragments in a voice and a context that bore no relationship to the original, then the court wasn't hearing the work. The court was hearing a constructed exhibit. The judges did not accept the argument. They allowed Rue's testimony to stand as evidence of what had been performed. The defense called its own witness. Dorothy Kilgallen, the prominent journalist and broadcaster, testified to Bruce's seriousness as a social critic. Richard Gilman, the drama critic at Newsweek, testified to the artistic structure of Bruce's work. Other witnesses included professors, journalists, and writers who could speak to what Bruce was doing within the tradition of American satire. The defense effort was substantial and well prepared. The court's response was to listen patiently and discount most of what was said. The judges had decided early in the proceeding what question they were answering. It was whether the words Rue had recorded violated the obscenity statute. Everything the expert witnesses said about the artistic merit of the larger work was treated as collateral. The verdict came on November 4th, 1964. Murtaugh and Creel voted to convict. Bruce was found guilty of 3 counts of giving an obscene performance. The third judge dissented. The dissent is a remarkable document in the history of American free speech law, and it's been remarkably underread. The dissenting judge argued at length that the majority had applied the Roth standard incorrectly. He argued that Bruce's work, considered as a whole, was clearly within the tradition of social and political satire that the First Amendment was designed to protect. He argued that the procedural decision had made the Roth standard impossible to apply. The court had kept the performances themselves out of the courtroom and tried the case entirely on Rue's reconstructed transcripts. Roth required the consideration of the whole work. The whole work had been deliberately excluded from the proceeding. The dissent was not a sentimental defense of Bruce. It was a technical legal critique of the majority's reasoning, and on the merits. The dissent was the more careful piece of jurisprudence, but it didn't control the outcome. Lenny Bruce was sentenced on December 21st, 1964. The sentence was 4 months in the workhouse on Rikers Island. Solomon, his co-defendant, was given a suspended sentence. Bruce remained free on bail pending appeal. The appeal was still pending on August 3, 1966, when Bruce died. He never had to serve a day of the sentence. He had also never been cleared of the conviction. The case sat in the appellate system attached to his name with no resolution and no further action. The state of New York had what it wanted. The conviction stood, the sentence stood, and the man whose career had been built on what language could do had been declared a criminal by the city that made him. The industry abandonment. Bruce's career didn't end because of the conviction. It ended because of what the conviction made possible. The day after the New York verdict in November 1964, Bruce's bookings began to collapse. Not in New York, where he had already lost the Cafe A Go-Go, where no other licensed venue would touch him, but everywhere. Clubs in Chicago that he'd been negotiating runs stopped returning calls. Clubs in Boston quietly removed him from their fall calendars. The Crescendo in Los Angeles, where he'd been a regular for years, stopped offering dates. Even the rooms in San Francisco, the city where he'd been acquitted, became cautious. The owners of those clubs were not making an aesthetic judgment about Bruce, they were doing the math. Every state had its own version of the New York State Liquor Authority. Every city had its own licensing apparatus. After November 1964, every one of those bodies knew that Lenny Bruce had been adjudicated obscene by a court of law in the most important media market in the country, and that determination was now available as the basis for action against any venue that booked him. The phone call didn't have to be made. The threat of the phone call was enough. By spring of 1965, Bruce had no major club bookings in any American city. The financial collapse came fast. He had been making good money through 1962, even with legal bills mounting, but by 1964, the bills were eating everything. The New York trial alone had run him tens of thousands of dollars, and the appeal was going to cost more. He put up his Hollywood Hills house as collateral. He sold his record collection, his furniture, and his cars. In October 1965, Bruce filed for bankruptcy in San Francisco federal court, listing assets of about $5,000 and debts of more than $40,000. Most of those debts were legal fees. The judge declared him what was called, in the language of the period, a legal pauper. The man who in 1962 had been one of the highest paid stand-up comedians in the country was, 3 years later, a man who couldn't afford a lawyer. Which is why by 1965, he was representing himself. His pro se appeals were not incompetent. Lawyers who watched Bruce work the law in his last 2 years said he'd become genuinely good at it. He understood the Roth standard. He understood the procedural arguments. He could read a brief. What he couldn't do was stay distant from the material. The material was his own life. By 1965, the obsession with the case and the case itself had become the same thing. He showed up to court with briefcases full of annotated documents. He talked about the case constantly. Friends who had known him for years said that by 1965, he couldn't hold a conversation about anything else for more than a few minutes. The case had eaten everything else. It had also eaten his act. The few performances Bruce gave in 1965 and 1966 increasingly consisted of him reading aloud from court transcripts, walking audiences through the legal arguments, or explaining where the prosecution had been wrong. The bits about religion and language in the country had been replaced by bits about the appellate structure. Audiences who came to see Lenny Bruce found themselves listening to a comedian who was no longer doing comedy. He was litigating. The stage had become an extension of the courtroom, except that in this courtroom, he was the only one talking, and there was no one to rule on his motions. The few people in the industry who would still helped him quietly. Phil Spector, who we've done a previous episode on, financed part of his later legal work. A handful of musician friends sent him money. His mother, Sally Marr, who had taught him comedy in the first place, was actively trying to keep him afloat. The bookings that did come in came from people willing to take their licensing risk for personal reasons, not commercial ones. Bill Graham ran the Fillmore Auditorium in San Francisco. In June 1966, he booked Bruce in what was effectively a defiant gesture. A rock and roll promoter, putting a comedian on the same stage where he ran the Grateful Dead in Jefferson Airplane. Graham had been managing his relationships with the city's authorities for years, knew what booking Lenny Bruce would cost him, and booked Bruce anyway. The show went well, but Bruce was dead 6 weeks later. This is what took down Alan Freed 8 years earlier. What finished Bruce wasn't the conviction. It was the slow, parallel withdrawal of everyone around him. Venue owners across the country, licensing boards in every state, and the SLA in New York all reached the same conclusion without having to coordinate. Booking Lenny Bruce was no longer worth it. The clubs that had made Bruce in the late 1950s, the Hungry Eye, the Crescendo, the Den, Ann's 440, had quietly stopped offering him dates and booked other acts. None of them put out a statement because they didn't need to. The empty dates said it for them. By the summer of 1966, Lenny Bruce was 40 years old and broke. He was banned in most of the country. He was addicted to the morphine that had become both his medical management and his escape, and he couldn't talk about anything other than the case. He was working on the appeal alone in a small house on Hollywood Boulevard, surrounded by legal papers when he died. What the obscenity laws were actually for. Before going further, the honest acknowledgement. Lenny Bruce was not a saint. He was a difficult man, increasingly an addicted one, and by his last 2 years, he was becoming hard to be around, even to the people who loved him. The drug use that had started as recreational had escalated into something that was killing him in installments. He had married a former stripper named Honey Harlow in 1951, fathered a daughter with her in 1955, and was a chaotic presence in both of their lives. Some of his late performances were not just litigation-obsessed, but genuinely incoherent. People who had known him at his peak in the late 1950s mourned a version of him that was already gone. He had been losing it for years before he actually died. Some of the people in the music and comedy industries who were relieved to see him gone in 1966 were not cynics. They were people who'd watched a friend disappear inside his own collapse and could not figure out how to help. None of that changes the argument about what was done to him. Because the question that has to be asked, when you pull back from the specifics of the Bruce case, is what American obscenity law was actually designed to do. And the answer, when you look at how the law was used, and against whom, is not what the law said it was for. The federal obscenity statute that most of the Bruce-era prosecutions were built on was the Comstock Act, passed by Congress in 1873. It was named after Anthony Comstock, a devout Christian and anti-vice crusader who lobbied for the law and then was appointed a special agent of the post office to enforce it. The statute prohibited the mailing of obscene, lewd, or lascivious material, which was defined so broadly that almost anything could fall under it. Comstock spent the next 40 years using the law to prosecute the people he wanted prosecuted, which turned out to be a fairly specific list. He prosecuted the publishers of birth control information. He prosecuted distributors of anatomy textbooks. He prosecuted Margaret Sanger in 1914 for publishing a newsletter called The Woman Rebel that explained how women could prevent pregnancy. Sanger fled the country rather than face trial, and the charges were eventually dropped. But Comstock had what he wanted. The Comstock Act was a tool. Whoever held it pointed it where they wanted. He prosecuted labor organizers. The industrial workers of the world saw their publications seized under obscenity statutes. Emma Goldman, the anarchist, was convicted of distributing obscene material, the obscene material being a pamphlet about birth control. Throughout the early 20th century, obscenity charges followed labor and radical politics with a consistency hard to explain by the content of what was being prosecuted. He prosecuted gay publications. One Magazine, the first widely distributed gay publication in the U.S., had its October 1954 issue seized by the post office on obscenity grounds. The magazine sued. One lost in district court, one lost in the Ninth Circuit, one won in the Supreme Court in 1958, in a decision that became the first major gay rights victory at the federal level. What had been obscene about the magazine in the post office's determination was not its language, it was the existence of openly gay people writing for and being read by other openly gay people. The post office couldn't prosecute people for being gay, so it prosecuted them for being obscene. It was the same prosecution under a different name. This is the lineage Lenny Bruce walked into. The federal and state obscenity statutes had a 90-year track record by 1961. They had been used against people whose real offense was political, religious, or sexual nonconformity. Obscenity was the available legal vehicle to go after them. The proof that this was something happening to Bruce, rather than something more straightforward about language, is the pattern of who was working this style of comedy in 1961 and who else was not being prosecuted. Belle Barth was selling out clubs in Florida and the Catskills, doing material vastly more sexually explicit than anything Bruce ever said on stage. Rusty Warren's record Knockers Up sold over 1 million copies in 1960 alone, filled with material that would have horrified the prosecutors who took Bruce to trial. Pearl Williams was working the same circuit. None of them were ever prosecuted by Frank Hogan's office or by any other major district attorney. Red Fox had been making explicit party records on the Dutone label since the late 1940s. Some of those records contain language that is genuinely shocking even now, and Fox was never arrested for any of it. He later went on to star in Sanford & Son. Don Rickles was building a career on insults that traded in every racial and ethnic stereotype available in 1950s America. But Rickles was never arrested. Some of the same prosecutors who pursued Bruce attended Rickles' shows in Las Vegas and laughed. The difference wasn't the words. The words Belle Barth, Rusty Ward, and Red Fox used were often the same words Lenny Bruce was using. The difference was what the words were for. Lenny Bruce was using them to make an argument. He was saying that organized religion was a business. He was saying that the harm a word could do came from the silence around it, not from the word itself. He was saying that the mainstream press was a propaganda operation. He was making a critique of American power that the people running American power didn't want made on stage in front of a paying audience. Belle Barth made dirty jokes, but Bruce made arguments. There was no statute against arguments, so Hogan reached for the one against obscenity. Hogan's office wasn't protecting the citizens of New York from dirty words. The citizens of New York could buy Belle Barth records at any Sam Goody. Hogan's office was protecting the archdiocese, the New York Democratic establishment, and itself from the argument, and it used the words as the excuse. The posthumous pardon and what it means. On December 23, 2003, New York Governor George Pataki granted Lenny Bruce a posthumous pardon for his 1964 obscenity conviction. It was the first posthumous pardon in the history of New York State. Bruce had been dead for 37 years. The pardon was the result of a multi-year campaign led by two legal scholars, Ronald Collins and David Scover, who had spent years researching the trial for what would become the definitive book on it, The Trials of Lenny Bruce. They were joined by First Amendment lawyers Robert Corn Revere and Floyd Abrams. The petition they assembled was signed by a long list of comedians, writers, and free speech advocates, including Robin Williams, Margaret Cho, the Smothers Brothers, Penn and Teller, Eric Idle, and Bob Dylan. The list also included people from the legal and journalism worlds who had no particular connection to comedy, who saw the conviction for what it was and wanted it undone on the record. Pataki granted the pardon as a free speech statement. He didn't name Frank Hogan or any of the three judges. He didn't say that the state of New York had failed Lenny Bruce in a way that destroyed him. He said only that the conviction was being set aside. A pardon doesn't erase the conviction from the record. It doesn't establish a legal precedent that other defendants can cite. It's an executive act, a statement by a governor that the conviction should no longer carry weight. What the Bruce pardon did was confirm officially what most thoughtful observers had concluded by the late 1960s, that the prosecution had been wrong, the conviction had been wrong, and the use of the obscenity statute against a comedian making political arguments had been an abuse of the law. What the pardon couldn't do is the part that matters. It couldn't give Lenny Bruce back the 4 years he spent in courtrooms instead of on stages. It couldn't give him back the bookings he lost, the house he sold, or the bankruptcy he was forced into. It couldn't undo the slow degradation of his act into legal recitation, the alienation of his friends, the morphine that had become his medicine and his exit. It couldn't give his daughter back her father. It couldn't give the audiences of 1964 and 1965 back the sets that Bruce never got to perform because he was in court instead. The pardon was the state of New York acknowledging in 2003 what the state of New York had done to Lenny Bruce in 1964. The acknowledgement came after every person who had made decisions was either dead or retired, and after every person who had been hurt by them was beyond hearing it. There's a useful comparison here, and it's to the Arbuckle case from 40 years before Bruce, detailed 4 episodes ago. When Roscoe Arbuckle was acquitted in 1922, the jury that acquitted him took 6 minutes to deliberate, and they spent 5 of those 6 minutes drafting a written apology. They handed the apology to Arbuckle in court. He kept it for the rest of his life. The apology didn't save his career. Will Hayes banned him from the industry 6 days later, but the apology was something the pardon wasn't. It was an acknowledgement delivered while Arbuckle was still in the room to receive it. Bruce's pardon came 37 years too late. It was the right outcome at the wrong moment, delivered to no one who could hear it. The pattern. The Lenny Bruce case isn't just about a comedian and a district attorney. It's a story about a quieter kind of American power, the kind that uses existing tools to do what no legislator would dare to put on a ballot. There was no Lenny Bruce law, no statute named for him, no bill that worked its way through Albany and got signed by the governor declaring that this man specifically could not work in the state of New York. What happened was something quieter, and in the long run, more effective. Frank Hogan's office filed an obscenity charge under a statute that had been on the books for 100 years. The New York State Liquor Authority let club owners know what would happen to their licenses if they booked Bruce. The NYPD Vice Squad attended his shows and took notes. The Department of Licenses sent a former CIA officer with a pad to a folk club in the village. Each of those actions was, on its face, the routine exercise of an existing legal power. Together, they accomplished what no legislature could have accomplished without a public fight. This is how the play actually works. The legislative branch is the loud branch. It's the branch that has to take votes and stand for re-election and answer to the press for what it does. The administrative branch, the prosecutorial branch, and the licensing branch are quieter. They don't take votes. They make decisions about specific applications, specific defendants, specific premises on a case-by-case basis, and the decisions are not always reported, and the patterns are not always visible until enough time has passed to see them. Once you see it in the Bruce case, you see it almost everywhere. You see it when a city denies a permit to a bookstore that stocks material the permitting officer finds objectionable on legitimate-sounding grounds, zoning, parking, fire code, and the bookstore moves 3 blocks, and the permitting officer has done his job without anyone having to pass an anti-bookstore law. You see it in 2023 when a state's alcohol control board threatens the licenses of bars that host drag performances. They use existing obscenity statutes written for entirely different purposes. The bars stop hosting the performances. No legislator anywhere has to vote on a drag ban, because a drag ban has already been accomplished by people whose names will not appear in any newspaper. You see it when a district attorney with political ambitions decides that a specific defendant is worth making a public example of. The DA uses prosecutorial discretion to file charges that another office wouldn't have filed. The defendant either takes the plea or spends years and tens of thousands of dollars on a defense. Either way, the message gets delivered to everyone else who might have been doing the same thing. The names can change. Frank Hogan is dead. Herbert Rue is dead. The New York State Liquor Authority of 1964 has been reorganized several times, but the play itself is durable because the play itself is built into the structure of American government, and the people who use the play know it. They don't have to coordinate, they don't have to conspire. They just make the routine decisions in their own jurisdiction in the direction the political moment encourages. The result is the same as if there had been a conspiracy. The lesson of the Lenny Bruce case is not that the obscenity law was bad, although it was. The lesson is that when a society decides to silence a person without admitting it's silencing them, it has plenty of ways to do it. Bruce was silenced by a coordinated effort that nobody had to coordinate. He was bankrupted by a campaign that nobody had to call a campaign. He was killed as much as anyone is killed by a non-physical thing, by people in offices in 3 different cities. Each of them would have told you then and now they were just doing their jobs. That is the most accurate description of what happened to Lenny Bruce, and it is the description that should worry you the most. Lenny Bruce is buried at Eden Memorial Park in Mission Hills, California. The grave is plain, but there is a marker. The conviction that was on appeal when he died was never resolved through the courts. It sat in the appellate system for 37 years, attached to his name, with no further action taken on either side. The state of New York didn't press to enforce the 4-month sentence. Bruce's estate didn't press to overturn the conviction. The case simply waited, in a file cabinet somewhere, until Pataki's pardon set it aside in 2003. The legal system that had put so much energy into ending Bruce's career had no further use for him once his career actually ended. His daughter, Kitty Bruce, has spent the decades since as the keeper of what was left behind. She runs a charity in his name, helping women in recovery from addiction. She's worked with biographers and documentary makers. She's done the slow, patient work of keeping her father's actual material in front of the public. The recordings, the manuscripts, the transcripts of the trial that consumed him. The version of Bruce his daughter has worked to preserve is the one he actually was, not the one the prosecution's left behind. Because the recordings exist, that's the thing to know. The clubs Bruce played in were rooms with tape recorders running, and those recordings have survived. You can listen to them now. You can hear the audience. You can hear the laughter at the line that the prosecution would later strip out of context. You can hear the silence at the line that landed harder than the laugh. You can hear Bruce shifting between voices, building the bit, taking the riff somewhere unexpected. You can hear what he was actually doing in the room. That is the work, and the work was the room. The transcript Herbert Rue took to Frank Hogan's office was not the work. The words on Rue's notepad were not the performance. They never were. And Frank Hogan knew that, and Herbert Rue knew that, and the 3 judges who heard the case knew that. And none of them had to say it out loud, because the entire purpose of the prosecution was to pretend that the words on the notepad were the only thing that mattered. The recordings still exist. Those recordings will outlast everything. This episode is dedicated to Lenny Bruce. The work was the room. I'm Lorne with Everything is Gray. Thanks for listening. This episode has been written, edited, and produced by Lorne Bregitzer.